going to get started. Welcome back to the open classroom on the rule of law in an age of polarization. I'm not going to change. We're delighted to have two distinguished guests here with us today, who will be introduced in a moment. But before we do that, I want to thank you both for being here. And thank you all for showing up on Valentine's Day. Hopefully you have great plans for afterwards. Flowers, chocolate, who knows what else. But,
thank you so much. It's my great privilege to introduce our two distinguished speakers tonight. As in the past, I'm going to introduce them. We're going to see the clips, and we've been told they work. And then our speakers will talk, and then we'll open it up for conversation. So let me introduce them sort of in order where they're sitting, and they will be speaking. So to my far left here is Peter Bennett. He is nationally recognized as a lawyer representing management in the field of labor and employment law, and is president of the Bennett Law Firm, and he practices here in the Boston area and in Portland, Maine. He's also a leader in the bar and currently serves as special advisor to the American Bar Association's Presidential Standing Committee on the American Justice System, and is a trustee of the National Judicial College, the nation's preeminent institution for the training of the judiciary. He has successfully represented management on matters of traditional labor and employment law for over 30 years, and is respected as being in the very highest echelon of lawyers in his field by inclusion in the Bar Register of Preeminent Lawyers, Martindale-Hubbell, Best Lawyers in America, Super Lawyers, and I can go on and on with all the accolades he has received. He received his bachelor's degree from Harvard University and his law degree from Boston University, and also has a master's and MBA from Boston University. Sitting next to Peter is the Honorable Fernande Duffly. Justice Duffly began her legal career in 1978 as an attorney in the litigation department of the then Boston law firm Warner and Stackpole. 8 years later, she became the first litigation partner and the first partner of color at the firm. She left private practice in 1992 after being appointed to the Probate and Family Court here in the Commonwealth of Massachusetts, and she served on that court until 2000, when she was appointed to the Massachusetts Appeals Court. And after a decade on that court, she was appointed as an Associate Justice of the Supreme Judicial Court, the highest court in the state of Massachusetts. A native of Indonesia, she was the first Asian American member of the SJC, and she retired on July 12, 2016. And we at Northeastern have the great privilege of having her join us as a visiting member of our faculty this year. And it is a real thrill to be on faculty with her. She has received the Distinguished Service Award from the Probate Judges Association, the Distinguished Jurors Award from the Massachusetts Association for Women Lawyers, and the Trailblazer Award from the National Asian Pacific American Bar Association, and has been recognized as a diversity hero by the Massachusetts Lawyers Weekly. She is also past president of the National Association of Women Judges. She received her bachelor's degree from the University of Connecticut and her law degree from Harvard Law School. So I'm really looking forward to hearing from both of our very distinguished speakers. And now, Steve, take it away. It's moving.
Good evening, everyone. I'm a member of what's known as the American Bar Association Standing Committee on the Federal Judiciary. And before I get to my slides, let me tell you why I enjoy serving on this committee and why I've done a lot of the volunteer work to advance judicial independence and the rule of law in my career. As somebody who represents either someone who's been wronged and needs to right a wrong, or somebody who's been accused of doing something wrong and needs to prove that they didn't, I find myself appearing in front of juries and judges, and ultimately, when wanting to be in front of a judge, all a trial lawyer wants is to have a good judge. We don't necessarily have to have the brightest judge, but we have to have a judge who understands the rule of law, who understands his or her obligation to do justice, and who understands that bias and prejudice don't enter into the process. And so that's been my motivation to do a lot of the work that I've done, and in particular to serve on this committee, which remarkably takes as many as 1,000 hours of work in any given year. The remarks I'm going to give to describe the work of our committee and our role in the judicial nomination process is all based on public information. Ratings that we give, and I'm not going to get into specifics too much, are all public. They've all been shared with the public. They're shared with the Senate Judiciary Committee. And so I'm not going to unlock the secrets if that's why you're here. What makes the American Bar Association so important in this process is that we are very unique in American society. The American Bar Association was founded in 1878. It is one of the largest volunteer professional associations in the world. We have over 400,000 members and have for a number of years. We are committed as an association to advancing the rule of law, and our membership represents all constituencies in the legal profession. And so that gives us a unique perspective from which we do our work in terms of not vetting nominees to the federal judiciary. The federal judiciary, for those of you who aren't familiar with it, begins with the Supreme Court of the United States, which is recognized specifically in the United States Constitution. The Supreme Court today has 9 justices. That hasn't been the case during the entirety of the Supreme Court's existence. For some time there were 6 justices, and then I want to say about 130, 140 years ago the court was expanded to 9. The Congress has the power to establish inferior courts, and so in our federal judicial system we have what is essentially 3 levels of courts. Immediately beneath the Supreme Court we have the United States Courts of Appeals, and those courts are staffed by 179 Court of Appeals judges. And then at the trial level we have the United States District Courts, and at the district court level there are 677 active judgeships. Within the federal system there are also additional judgeships for what are called active retired judges. When a judge has served for long enough and meets a certain formula, he or she is eligible to retire. But many judges choose to stay on and continue to hear cases even though the remuneration is the same whether they retire or they continue to work. Our committee rates every one of these judges when there's an opening and a nomination. Currently, there are 140 openings in the federal court system. In recent years, there had been over 200. The current president is actively nominating folks to the federal bench. Allegedly, the nominations are going to start coming at a pace of about 10 per month. Just to give you a feel for how the courts are split up, there are various judicial circuits. Each one has its own court of appeals. If you can see the screen, you can see that there are 11 up there. There's also a court of appeals in the District of Columbia Circuit that basically is for the District of Columbia, and there's also a federal court of appeals. We're in the First Circuit, which covers Maine, New Hampshire, Massachusetts, Rhode Island, and Puerto Rico. In our circuit, we have very few vacancies. These are the courts that currently have vacancies. There are 2 district courts in Massachusetts, 1 in Maine, 1 in Puerto Rico, and 1 in Rhode Island. As you can see, 4 out of the 5 have taken senior status, which means that they are still actively carrying a caseload and hearing cases. They just step aside, let somebody who wants to work full-time have their seat, and it helps to spread the workload. Let me give you a little history, if I can, about the Standing Committee on the Federal Judiciary. The American Bar Association established a committee in 1948 to evaluate and report to the United States Senate on nominations. In 1953, President Eisenhower, and I will note a Republican, came to the American Bar Association and asked us to review nominations of the people he wanted to nominate to the United States, to all the federal courts. The reason President Eisenhower asked the American Bar Association to take an active role in the nomination process was because he was tired of being pressured by political interests, asking for political paybacks that were pressuring him to nominate people who might or might not be qualified for judgeships. And that's how we began, and since then we've served 10 administrations. The nomination process that we go through is historically a pre-nomination review. For the district court openings and the Court of Appeal openings, historically, and there are 2 exceptions which I will get to, but historically the White House has forwarded the nominations to our committee before the nominations are made public. The reason for doing that is several-fold, but I'll give you a couple of the reasons. One, if our committee determines that a nominee might not be qualified for the nomination, it's a benefit to most White House administrations and to virtually all nominees for that knowledge to be known in advance. It may cause the White House to withdraw the nomination. It might also cause the nominee to withdraw his or her name from consideration. Another reason why doing a pre-nomination review has been so important historically is that if a practicing lawyer is nominated to the bench, while that nomination is pending, his or her legal practice tends to dry up because their clients know that at some point they will be assuming the bench and will not be in a position to represent them and continue their cases any longer. And so there's a personal impact on nominees that influences this process as well. The pre-nomination review has historically been only for district court and Court of Appeals nominees. The Supreme Court of the United States has always been treated differently, and that has always been a post-nomination review. I mentioned that there have been 2 exceptions in terms of how administrations have worked with our committee. During the administration of George W. Bush, all of our work was done post-nomination, and our reports went directly to the Senate Judiciary Committee. We reestablished the prior relationship with the White House during the Obama administration. During the Trump administration, we've gone back to what we had essentially during the George W. Bush administration. We do our vetting after the nominee has been publicly announced, and we report. Actually, under the Trump administration, we issue our report to both the Chief Counsel in the White House, Mr. McGahn, and to the Senate Judiciary Committee. Our committee has 15 members. 14 of us serve 3-year terms. The 15th is the chair. If you go back to that slide that had the map of the United States and it had all the judicial circuits, every member of our committee represents one judicial circuit. There are 13 judicial circuits when you add them up. The Ninth Circuit, which is on the West Coast, is a particularly large judicial circuit, and as a result, our committee has 2 members who represent the Ninth Circuit. The chair serves a 1-year term typically, and as I've described to you, we review nominations for all Article III courts. We strive very hard in terms of how we administer our committee to maintain our independence and impartiality. To serve on the Standing Committee on the Federal Judiciary, to be a member of what you cannot be an office holder or a candidate for office in the American Bar Association. One of my fellow committee members recently resigned from our committee because he wants to run for an ABA office, and the fact that he wanted to run meant that he had to resign. When we're on the committee, we have to make a commitment that we will not seek or accept a nomination of the federal judiciary while we serve on the committee and for at least 1 year after we're done with our term. We also commit not to engage in any federal election campaign or partisan political activity, and that includes any political donations. Most of us who serve on the committee see that as actually a benefit, because when we get hit up for money, we have an automatic out and can say no. Interestingly, I'm going to digress for a second. We recently had a nominee, Judge Graz, who was nominated to the 8th Circuit Court of Appeals, and our committee rated him not qualified. It became a very controversial rating. It received a lot of play in the press. I'm going to talk a little bit about what a not qualified means in terms of our committee's work in a few minutes. But when 3 members of our committee were basically called on the carpet before the Senate Judiciary Committee over this nomination, the senators who had prepared to ask questions of our committee members had looked into the political giving history of each of those members and, in fact, of our entire committee. And I was singled out for, not by name fortunately, but for not giving very much, but only giving to Republicans. But the fact that I'd only given to Republicans didn't matter. It was the fact I hadn't given much. Long story short, though, we are apolitical. And finally, we make a commitment that we will not belong to any organization that discriminates. Our process is incredibly detailed. I can't begin to tell you how much work goes into vetting a nomination. Judge Gorsuch, who was on the video that you saw, our investigation of Judge Gorsuch, which for a Supreme Court nomination, there's one lead reviewer, but the entire committee shares the work, began with the mailing of over 5,000 letters of inquiry to people around the United States asking for input on Judge Gorsuch's qualifications. We have a strictly confidential process. We do not disclose the names of the people we interview. We do not disclose our work product. No one beyond the 15 members of our committee has access to our work product. This includes the ABA staff who support our committee. Our work product is not subject to the Freedom of Information Act, and we've had skirmishes with the politicians who wanted to get into our files, and the privacy of our work has been maintained. Because of that, and because of the historical nature of our work, and because of the stature and reputation of the American Bar Association, at times our committee gets access to information that not even the FBI has been able to uncover. And the work is done by each of us personally. That's very important. We don't delegate the important work. We send out these letters, we conduct interviews, We do all of the background digging and research on our own. And as part of each nomination, the evaluator who's assigned conducts a personal interview that typically lasts between 3 and 4 hours, sometimes longer. And it's meant to be a thorough process. So when I said earlier that the commitment our committee members make is to spend as much as 1,000 hours a year vetting nominees, I was being serious. In terms of our process, when a nomination comes out, we make a commitment to turn the nomination around within 35 days. In the 55 years that this committee's been formally recognized by the White House, we have met that mark with rare exception. That was true even during the George W. Bush administration when the nominations came out, when the reviews were done post-nomination, and that has generally been true during this administration. Typically, the person assigned to conduct the review is the circuit member in the same circuit as the nominee. During this administration, that's been a little difficult because of the number of nominations that we've had to do. We begin our process by reviewing what's on the screen as the personal data questionnaire, but is also known as the Senate Judiciary or Senate Data Questionnaire. It's a very thorough form that each nominee is required to fill out that provides a blanket summary of their qualifications and of their life's work. We mail out several hundred letters. Unlike the Supreme Court, when you have a nominee who's local, the letters number in the hundreds. We write to every possible judge practicing or sitting in the jurisdiction of the nominee. We write to every lawyer who's been identified in the Senate questionnaire. We do a search online on Westlaw to find other cases and identify other lawyers. We write to them. We contact bar leaders. We identify the minority bars in the jurisdiction and write to the leaders of those bars. And we try to find the people who may have information that will tell us whether this nominee is good or not. As the process continues, we do confidential interviews. We set a goal for each nominee to do a minimum of 40 interviews of judges and lawyers who have firsthand knowledge of the nominee. In most instances, we can find 40. There are times when we can't. If we have a judge who's being promoted to a court, we try to read the judge's reported cases. And more importantly, we look at times when that judge has been reversed on appeal to see what the reasoning is of the appellate court and to see if we have somebody who's a quality jurist. We do research to find the nominees' legal writings and review those. We research their disciplinary records. We go on the internet and do a search and look for speeches and blogs and interviews and always seem to find information, some of it entertaining, some of it unfortunate, and some of it that proves that the nominee is very qualified. And as I mentioned, we do an in-person interview. When all that's done, we prepare a report. The typical report runs somewhere between 200 and 600 pages. It's a thorough assessment of the nominee's background. It provides the committee with contact lists, with interview summaries, with a summary of the interview of the nominee, with specific attention to any negative information that comes out. We include copies of writings or samples of writings, the responses from the disciplinary authorities, and then the person assigned to do the review makes a recommendation to the committee of what he or she believes the rating ought to be. Before the report is sent to the committee, the chair of the committee reviews that report and provides, currently it's a her, provides her input. And then the committee is given the report to consider, deliberate on, and vote. Every member of our committee is charged with voting independently of the other 14 members of the committee. Every member of the committee can call the evaluator and ask any question he or she wants. But the key to keep in mind here is that each vote is cast independently. What I have seen in the deliberations of our committee is that the votes are cast independently and that there is never any discussion of politics in this process. And by having people cast their votes independently, it helps to strip any opportunity from politics to enter the process. What we look at, since we don't look at politics, are three things, and only three things. We want to make sure that somebody who's going to receive a lifetime appointment is professionally competent, that he or she has the intellect to do the job, that they have the judgment to do the job, that they can analyze things, and that they can write clearly and coherently. Secondly, we look at the nominee's integrity. We research into their character. We look at their reputation within the legal profession as well as in the community that they live in and work in. And finally, and this has been kind of the lightning rod of our work this year, we look at the nominee's judicial temperament. We assess, is this person compassionate? Is this person able to be decisive? Are they open-minded? Will they respect precedent when they have to? Will they treat litigants with courtesy? When I was a young lawyer practicing, one of the things that bothered me most about appearing in court is that judges didn't always treat lawyers with respect and didn't always treat litigants with respect. I remember having a case that both lawyers said would take 3 weeks to try, and the judge came back and told us that he'd decided that we were going to get half that amount of time to try the case, and if we didn't like it, there wasn't much we could do about it until the case was over, and then whoever lost could appeal. We try to find judges today who want to be courteous to litigants, want to make the process work well for everybody. We want people who are committed to equal justice under the law. And those are the only three things that we look at. And as I mentioned, the temperament issue has been lately the source of a lot of publicity. We only give 3 ratings out. Well qualified. Judge Gorsuch is a great example of someone who is well qualified. It is hard to find fault with him when you look at his integrity, when you look at his temperament, and when you look at his intellect. Qualified, which is where the vast majority of nominees tend to fall, that is still a person who meets extremely high standards. And then the unfortunate few who are rated not qualified. I believe during the Trump administration, our committee has reviewed 50 nominees, and I believe there have been 3 who've received not qualified. When someone is going to be rated not qualified because of the impact it has on that person's reputation, what our committee does before we issue any report is we assign a second reviewer who conducts a second independent review. And both reports are generated and placed before our committee. No nominee to the federal courts in this country is going to be rated not qualified unless he or she has been vetted twice and independently. Finally, when we're done, the outcome of our process is a letter that is sent to the Senate Judiciary Committee, to the chair and to the minority chair, and to the White House counsel. We only provide the rating if the nominee is rated not qualified. We do provide some of the reasoning that goes into it. Let me wrap up by saying what we don't do. We only do a peer review. I'm not sure I'm a peer from virtually anybody I've been asked to assess, but Many of our people are of much higher stature than I am, and we hold ourselves out as doing a peer review. We do not engage in the nomination process, and we never consider politics. We never consider a nominee's ideology or philosophy, and we never consider ABA policy as part of our process. We actually function independently from the American Bar Association. And with that, I'll turn the program over to Justice Duffly. Thank you.
I've actually been involved in a small piece of what Peter does because as a justice for so many years, I received those letters and took them very seriously. It was a really important part of that process. I understood that it was, and I took that job seriously, always answering when I knew anything about the candidates. In fact, going as far, seriously consider whether I had anything good or bad to say and responding in that way. A very important part. So I'm not on the federal bench, and the state bench where I come from, Massachusetts Supreme Judicial Court, and before that the Intermediate Appellate Court, and before that a trial court, the Probate and Family Court, does, however, function quite a bit like the court that you just heard about. That's not a coincidence. Massachusetts is in fact the template for the federal judicial system, along with Virginia, which also claims that honor. So I'm going to give you a little history about my court, which was established in 1692, and we like to say we are the oldest court in continuous functioning existence in the Western Hemisphere. It's a mouthful, and most of us know it by heart. We like to say it often. We're very proud of it. I think actually Maine may claim it as well, but we say it more often and loudly. So,
well, we actually were part of Massachusetts at one point.
Maybe that's why you say it, right? So I want to give you a little bit of this background for Massachusetts, and then we'll go over how other states do this. You know, there are 50 states, and each of us has a somewhat different system for electing or appointing our judges, our judicial system. And I'm intimately familiar, as you have heard already several times. I've been appointed to 3 different courts on our court system, and I've been an actual judge for nearly 25 of those years. One of my colleagues, by the way, I want to shout out to Mitch on the appeals court. It was a thoroughly collegial court, as every court I belonged to was, and there's a special meaning to collegial when you talk about appellate courts. Well, we ran the night shift, right? We were always there at the same time at night. Collegial court means not just friendly, although every court I sat on was that way. Collegial court means that you sit in panels, and you talk in panels, you deliberate in panels, and that's called a collegial court. It's a very important part of the process of deliberating, as I'll come back to, and you can see why. So how did I get to these courts? In Massachusetts, let me just first say, I take this seriously. So let me start that this is much like the Constitution of the United States. Again, we were the template, and here's what I want to point to. It's essential, right, all of these things, that there be an impartial interpretation of the laws and administration of justice. It's the right of every citizen to be tried by judges as free, impartial, and independent as the lot of humanity will admit. So they say how you do that should be lifetime, and you shouldn't, your purse string shouldn't be tied to the legislature. Massachusetts did have lifetime tenure, as does the federal bench. It was changed by constitutional referendum. Now life ends at 70 in Massachusetts, so that wasn't the reason I retired. I'm not 70 yet, but I will soon be. But I could have stayed till the age of 70. And we do not have recall on the appellate benches in Massachusetts. So although we had it for a while, this business of being a senior judge where you come back for very little money, I think it's 25 cents on the dollar, for some reason somebody decided that was too expensive to have all of that talent come back. So we don't do that in Massachusetts. The governor selects, nominates the person who is going to be sitting on every single opening in the Massachusetts Judiciary, which was something in the 300s when I began. It might be closer to 400 at this point. Lots of openings when people retire. He does so, though, and there has been a she, but there's all the ones been appointed by 3 judges, 2 Republicans and 1 Democrat. I've been unenrolled for more than 25 years. It was a new thing for me to get to vote again after 25 years of political silence. I voted, but I couldn't talk about it. And I was unenrolled during all that time. So it isn't, though, just the judge, the governor that nominates the judge. He doesn't just look among his friends. That actually was a little bit more what it was like before me. In fact, my mentor, Sam Adams, tells me that the way he got to the highly revered judge, by the way, and from that family. His friend, Governor Sargent, called him and said, "Hey, Sam, would you like to be a judge?" And that's how he became a judge. But a highly revered judge on the Massachusetts Superior Court, who then came back to the firm where I was then a partner, and he became my mentor. Now, and since then, by executive order, there is a Judicial Nominating Commission. And that's a commission that's also bipartisan. It can be made up of anywhere from 15 to 20 people. And every time I've appeared before a body for one of the high courts, I appear before all of those people. The way you get to that point at this point, again, this has changed somewhat over the years, but you complete a very, very long application that tells someone reading it everything there is to know about you as a lawyer and as a person. And so you might put people down who might recommend you, but there's also a list of the trials that you've conducted and the people who were on the other side. And those are the people who also get called by members of the Judicial Nominating Commission. So you can see it functions very much in a similar fashion to the vetting that Peter's committee does. And that is done with every single appointment to a Massachusetts bench. And so I mentioned this application, and I go like this because it's about that thick. And I always warn people who want to be considered for judicial office, start doing it a long time before you think about that if you ever think you're going to do it, because you're going to need so much information that you'll never be able to find again if you think of it just before you say, okay, now's the time. It just wants to know everything about your whole life, because that's what they're interested in. What kind of person are you? What kind of temperament do you have? What's your relationship with other people? Not just your writings and everything you've done and who you've represented and whether you've had experience and how other people think of you, but ways in which they can really make that deep assessment. So that's what the committee does. And then, at least in later years, they give something like 3 names to the governor from which the governor may select. But before the governor makes a final selection, it then goes out to what they call the joint bar. And this is just, the name goes out to a committee made up of all the bar associations in Massachusetts, and they get to chime in too. So if they've heard things about you that haven't burbled up through all of the vetting that the commission, the JNC has done, it will come out. If you're really not a nice person, but you've really tried hard to pretend to be for the last 5 years, it might come out that way. So that's the point of that committee. And then finally, once the governor nominates you, you're still not a judge. We also have a political component. It's not the Senate, but it's similar. It's something that, how many here are from Massachusetts and are voters here? Okay. Do you know who your governor's counselor is? Who does? There are a couple in here. Few. All right. Not many people do. People in this room I kind of expect to, especially tonight. But most people do not even know what a governor's counselor is. The governor's counselor does a couple of things. One, they say yay or nay to a judicial appointment. And I think they also do commutations, something like that. Important jobs, very important jobs, but interestingly, most people don't know when they vote who they're voting for this important job. Nonetheless, I was able to manage to get past these people, and then there is a public hearing at which people can also make their, as we do for the Supreme Court. And I once had the privilege of testifying on behalf of one of our Supreme Court nominees, and that is what happens in Massachusetts as well. People can be there and in front of the Governor's Council and speak for or against a candidate. So let me go through this just a little bit to compare it to something I'm not familiar with, but I thought you'd be interested in some of the numbers. Massachusetts is unique in some ways in this country. You'd think it would be the template for everything. I think it's a great system. I think that we strive hard to be impartial as judges. But I know a lot of judges. Let me point that out. First, as a president of the National Association of Judges, I certainly know a lot of judges there. But I know a lot of judges from the ABA as well, and a whole other places. And I was once on a think tank kind of long weekend at Kettering where we were talking about different kinds of appointment processes. Everybody thinks that they can be impartial and fair. Everybody who's a judge, no matter how they got to that place, believes in their heart that they are impartial and fair. So, I believe them that they believe it. I think our system is pretty great, but there are many other systems. So I'm showing you this because I thought I could do this, but there are really quite a lot of studies, and there's a more recent study, just if you want to take a look at some of them, I'm glad to provide this information to you. There's been a lot of studies about whether you could introduce partisanship into the process and what that looks like. And I thought it would be interesting because most of these come out, and there's a 2016 study as well that I don't have up there, I just found it, but most of these come out saying that it's not so much politics, although there's one study that suggests politics is part of this issue. Mostly it's about money, and it's mostly about interest group money. And that's the biggest concern in terms of elections these days, that there's so much money coming from outside interests that wants to put the thumb on the electing process that goes on in more than, I think it's either 38 or 39 states that have some form of an election for their judicial officers. And the cost for some of these, the latest number I could come up with, it was something like, in 2016, somebody running for office for a high court for TV commercials alone had spent $644,000. One person, one campaign. I think it's over 45 million nationwide now that is expended on campaigns for judicial office. So this is the rundown, so you know that there are 12 states, including Massachusetts, that grant life tenure or 70, or some kind of long-term tenure or use reappointment of some type of their highest courts. 17 have uncontested retention, 14 have nonpartisan elections, and 7 have partisan elections. Like I said, 38, it might be 39. Some people say it's 39, and I couldn't find which would be the 39th, so I'm just going to leave it at 38. Here it says 39. That's the states that have intermediate appellate courts, like Massachusetts. And again, there's a rundown. You can see it's only 8 of those that grant life tenure or use reappointment of some type for intermediate appellate courts. You can see we are in the minority, and that's the same rundown for trial courts as well. There's that number. Candidate fundraising raised a total of $45.6 million. This is in 2000, and that number has exponentially increased since then. A lot of money going into judicial elections, and particularly of concern to some people is this interest group activity that has increased over time. What does this mean to the voter? 76% of voters and 26% of state judges believe that campaign contributions have at least some influence on their decisions. 62% of voters, and including 90% of African American voters, feel that there are 2 systems of justice in the United States, one for the rich and powerful and one for everyone else. 9 in 10 voters, 8 in 10 state judges say they are quite concerned about the special interest groups buying advertising to influence the outcomes of judicial elections. So I wanted to talk to you a little bit about my own personal experience. I thought since I had that experience and I can be a little bit more free in talking to you about what that was like, I'd like to talk to you what it means to me when I say that I think I am impartial. I hope I am. And talk to you a little bit about what it means in terms of day-to-day practice on the Supreme Judicial Court and on the Intermediate Appellate Court. And if you disagree with me, just raise your hand, and I will call on you, Mitch. I don't think he's going to raise his hand. I think he's going to agree with everything I say about this. So when I say independent, I don't mean isolated, and I don't mean secluded. I actually believe that judges should get out there and talk to people. I think that people should know who their judges are. I think people should recognize me in a supermarket, as they often do, and say, Justice Duffly, I didn't know you went shopping, things like that. And I want them to see that, yes, I go shopping. I do. I buy groceries. I eat food. And I think it's important for people to know that. And it's important for me to know them as well. Not to be influenced by them. Not that I want them to see me, go to a bar and get tipsy, because I don't. In fact, I don't drink in bars for that very reason, only at home. I want people to not feel that we are in an ivory tower, right? I think that's really important. And in fact, I had the opportunity first testifying when they did the judicial code change at the ABA, and then when I became a justice on the Supreme Court, as head of the Rules Committee, we also changed our judicial code to make it explicit that judges should be out there. If you're going to go speak to one side, however, then you're going to speak to the other side as well. So you have to be nonpartisan. In that respect, you have to be even-handed, but you should be out there and let people see you and know who you are, so that you're not just some unknown who sits in a black robe and nobody knows what it is that you do. Another thing that I don't mean by independent and impartial is I think that people do come to the bench with their own experiences. I think that is an important thing. If you look and read opinions, if you love to read opinions like I do, and read some from way back with great names like Holmes, a revered person, sometimes you read things that Holmes wrote and you cringe. And you cringe because of the way he writes about women and sometimes minority groups, and you think, oh my gosh, I don't even want to know that about him. But it's really a lack of experiences. When you get a bunch of people who were just white men who really were elites in their time, and they were picked from the elite, from the wealthy, people who were educated at Harvard, and that's pretty much it in those days, what do you expect? Their world is so narrow. I think what it means to have a healthy judiciary is to have a judiciary that is made up of people who have broad experiences. So you heard a little bit about mine. I was born in Indonesia. In fact, I was born to a Chinese mother and a Dutch father. And we left when I was a year quickly because of a regime change that was very anti-Chinese. And we wanted to come to the United States, but we couldn't because of quotas in the United States against Chinese. 105 people a year were allowed to come in, and it would have taken, I would have been an adult before we'd come in. So Eisenhower was a familiar name in our household. It was the Eisenhower Refugee Relief Act that permitted our entry into the United States as refugees when I was 6 years old, just before Thanksgiving. So I'm always grateful to Eisenhower for that. And I think that that experience actually, as a woman, as an Asian American of mixed race, as a refugee in this country, is something that I brought with me to my judicial decision-making when it was appropriate. The fact that we were poor when we first came, the fact that we valued education, all of those things actually, I think, gave me a perspective on life that was a valuable perspective to bring to my job. So what do I mean by that? Well, I'm going to give you, with some caution, an example, right? What does it mean? So in a collegial court, it means that, does anybody know how we do our work on the SJC? Except you, Mitch, you can't answer that. No. So you know that we sit there in black robes, right? You've seen that picture. We sit there and we look a little stern, but we're listening. We're listening hard. After we listen hard, but let's start with before. Before we even get there, we read all these briefs. For every case on the SJC, there's not one side, two side. There's one side, two side, and then a reply, and then other people, amicus briefs, weighing in. They're very important to give us a full understanding of the legal issues that are being presented to us. And we read these before we go on the bench. Some of us read them more carefully because it'll be our job after we sit and we listen to the people who are arguing, the lawyers who are arguing on both sides, and we listen attentively because they are educating us. Then we go back into our deliberation room, and we have a preliminary deliberation. One person who has looked more closely than it's a big job, more closely than the other 6, gives a summary of the salient points and the research that has gone into that, and summarizes it, and then has a tentative conclusion. We call it a sample, it's French. It seems that the outcome might be this way, and then we vote in seniority. It's very formal. We call each other justice in that room, but not outside. It's an old tradition, and we like tradition to some extent on the SJC. The point of that is to get a sense of the room, so that the chief can then decide who's going to write the opinion. If you don't have a sense of how people are thinking, how can you ask somebody who's not a majority to write a majority opinion? So that is the purpose of that. The writer, who is selected by the chief in each case, if you were sitting there, he might appoint you, but he wouldn't appoint you because you had been voting in the opposite direction. So that's how the work is distributed. We write about 24 of those major opinions a year. We write dissents and concurrences as well, and that doesn't even count the bar disciplinary opinions and a bunch of other stuff. So, but the big work that you know about, that's what we then do. And then we go back and we write the opinion. If I've gotten a majority opinion to write, it will take me some time with my clerks. We think about it, we do the research. On average, we have at least 20, 25 versions of final, and you don't circulate it until you think it's final. Of course, it's not final at that point, but you have to get it as final as you think it can be before you share it with your colleagues. At that point, all your colleagues read it. And at that point, we go back into that same deliberation room and we talk about it. And we talk at great length about each of these decisions. And that's when you get the comments about why is it this way, why is it that way, I disagree with this, here's what I think about the law. And again, it's very formal, and it goes around the room, beginning with the most senior to the least senior. And the final vote is with the chief, but we first indicate whether we agree or don't agree with this version, and then you can make more extensive comments. It is in the course of that deliberation where having a lot of people with different backgrounds becomes most important, because the law, which always is about precedent, that's what we look to, and about legal principles and about what a statute means or doesn't mean, sometimes is informed by your own experience, right? And so we have prosecutors who have a particular experience. Maybe they also have an ideology, but more important, they have an experience with criminal prosecution that I don't have. I have particular experience with being a family court judge. And so, in no surprise, we've also had many family court cases coming to our court because I could see which of those cases might make a difference if we took another look at them. Another unsurprising thing is I might have an opinion, for example, if a case involves a refugee issue. So if, for example, I'm going to speak only in hypotheticals at the moment, you'll understand. If somebody were to have, if we were to have the issue that involves whether somebody could make, could have a new trial because their lawyer didn't tell them that if they pled guilty, they would be deported to a place they had only known as an infant. Somebody didn't know that. And we were trying to decide whether it made sense under the law, under our principles of law, to give them that opportunity because they got the wrong advice or not. Some people might say, he got a good deal. He got 2 years and he could have had 20. Other people might say, if you were banished for life to a place you don't remember and you've never been and couldn't earn a living and you don't have any friends or family, you might consider that a life sentence or even a death sentence. That is the kind of discussion that you can have in a deliberation room when people of different experience are appointed to a collegial bench. I have no time left, right? Oh, still 2 minutes. But really I have to say that it was the most rewarding and fulfilling opportunity to do this kind of work and service on the courts that I've served with. And everything, there really was nothing bad about it. In fact, I really loved the fact that my colleagues sometimes disagreed, and that in the end, what we had was a really collegial opinion. That means a decision that had the input of smart and thoughtful individuals who really wanted to make the right decision. So that was my experience every single time I had the opportunity to deliberate on a collegial bench, and I can't think of anything better except maybe teaching here, which I enjoyed immensely. And if there are any questions, I'm really happy to answer them now.
We're gonna
be both.
Okay, wonderful. Thank you very much.
In your talk, Justice Duffly, you said a few times that the role of the judges, first and foremost, is to pay attention to laws and principles. And Mr. Bennett, you said in the course of the deliberations of the committee on which you serve, the politics and the philosophy and ideology are not what you look at. I think it's fair to say from the clips that we showed at the beginning that spirit of impartiality and non-political judging has come under threat in the country and certainly under question from the populace. What steps do you think that the country can take to try to take the position that both of you have taken as sort of bedrock to what it means to be a judge in this country and revive them?
We kind of worked, you know, something that we've tried to do, right? So I don't know what you can really do. So part of the National Association of Judges' concern about this manifested itself in a video and a training opportunity. It was called Informed Voter. And with the League of Women Voters, we produced a video and had a training module that went out to states where there were elections, really focusing on the importance of informed voters. I mean, I think that's what since most of the country has elected judicial officers, you have to be informed if you're going to be voting for your judicial officers. And I think the education process is to let people know how important it is. They can't ignore it, and they have to understand who they're voting for and why to become informed about it. So that was one effort.
That's an effort that Justice Duffly was nice enough to let me help with. It's important, and I've also been involved in projects that are focused on civics, as Justice O'Connor did, and it's generational. We need to start educating our kids not only about the importance of voting, but about the role courts play in this country and what judges do on a daily basis. Another thing that we need to do is either shore up or restore confidence in the courts. Some of the bar associations have created what I'll call rapid response teams or rapid response toolkits that they disseminate within their bar associations. And part of that is because judges are very limited in what they can and can't say after they've written an opinion and have come under criticism. But we as lawyers can say whatever the heck we want, or more or less. And we are the best spokespeople sometimes to defend the integrity of the system.
That's great. I actually wanted to ask a little bit more, and I think this is probably primarily to Justice Duffly. You had talked about figures showing some decline in trust in the courts or confidence in the courts among the population. I'm wondering, is that coming into the courtroom? Are we seeing, you know, and does it influence, in the sense we've been talking a lot about rule of law and norms and people, how important it is for people to, in a sense, believe in the rule of law. I'm wondering whether you see a decline in that, and if so,
I don't see a decline so much in Massachusetts, but because I'm so involved nationally with the judicial system, there is a national concern, I'll say, that as judges, and then this is part of why I think we should speak. You want, I mean, the whole idea of having trust in the system is really important. I mean, if people start just thinking they're just making it up as they go along, you know, who cares? Then I think the whole foundation of our democracy is at stake, literally. You know, we really do need to make sure that that trust and that belief that we are being fair to everybody. Now, the best thing I loved as a trial judge, you don't hear this much from appellants, is, Judge, I know you decided against me, but you did a fair job. Thank you. And when I got that, that made my day, my year. I mean, that's the kind of thing you want to be. You can't just split the baby. You have to make a decision, and you have to make it in a way that they understand that what you're doing is not some arbitrary thing, but something that came after really thinking about what both positions were. And how do you do that? How do you really convey that, except one-on-one, one by one? And we do a lot of training with new judges about that, about not just listening, but doing it in a way that people know you are listening and understanding. Just things like that. I think it's so important.
Can I chime in? In the course of doing our nomination work, when we've had sitting judges nominated to either a district judgeship or an appellate judgeship, those who have stood out the best are those who are very careful in their opinion writing and who go to great lengths to explain exactly why they ruled the way they did, and also to be clear why they didn't agree with the side that lost in the case. And that does help the system function.
I guess it may be that I ended up on the appeals court. I didn't plan to do that because I believe that. I decided that it was important to write on the probate and family court, very busy court. So not just for my own thinking, that was part of it. So people would understand how I got to where I got. And I almost never got appealed as a consequence. I think that was the reason.
Great. Why don't we open it up for the questions?
I guess I have a really hard time understanding how there can be impartial judges when they're elected. I mean, they're running on a platform, they're voted into office by people who have particular ideologies or a particular way of thinking. They expect the judge to find according to that way of thinking, and they try and vote them out of office if they don't find that way. So how could they possibly be impartial?
I don't work in those areas, so I can't say, except from this example. There was an example of, when you see judges on state appellate court, high court, make decisions that they know will have consequence, but they are the decisions that make sense under their constitution, and then they get voted out of office. I mean, that's when you know you have impartial judges. I mean, that's unfortunate. But I think that just because you're elected, and I'm glad I don't have to run for office, let me just say that, but it is the way people are made judges in most states. And these people, and I know them, are hardworking and understand what the rule of law is. So it's not, a lot of these are nonpartisan, by the way. Just because they're elected in every state doesn't mean it's Democrats, it's somebody else. It doesn't necessarily mean that. And sometimes it's nonpartisan and sometimes it's partisan, but it doesn't necessarily reflect political persuasion. It's probably more the ideological things that you'd be more concerned about. I think I see that more now, though, than ever before. So, and that just may be new, but I think it's fairly new. And I don't know how it is affected by the outside money in terms of its impact on individual state elections or not. I couldn't say. So I'll direct you to the research.
Right, so just one thing you should know, Justice O'Connor agrees with you. Since she stepped down from the Supreme Court, she spent a lot of her time going around the country talking about state courts and how appointment around an election.
This was terrific. I've been watching Senate hearings, for Supreme Court nominees, et cetera, for a long time, and it seemed like there was a third rail years ago, 20 to 25 years ago, where you couldn't ask the judge, the nominee, how he was going to do would judge a particular situation coming up. Then that seemed to slide a little bit. Nowadays, it seems like we have presidential candidates, basically, or candidates, in this case, President Trump, basically saying, when I get elected, I'm going to select judges that will do this, that, or the other thing. So with that, how can the average citizen like myself have confidence that we are nominating and selecting judges that are impartial? And I really find it difficult to have a degree of confidence in that.
So I would agree with you that it's difficult to have a degree of confidence based on what you see in the media. But what I can tell you in practice is that in most states, the names of the people who are nominated come up through nominating commissions. Not every state does the federal system, or not every state's senators run their nomination system that way, but a great deal of them do now. And the nominating commissions are bipartisan. They are intended to be apolitical, and they typically select multiple well-qualified names that are then submitted for consideration. The level of contact that takes place between the White House and a nominee is minimal. And so there is some protection in the system for what goes on. Of the people I've interviewed during in running my nominations, the majority of them may have applied for a judgeship in the past, and as a matter of timing or something else, didn't make it, but they all seem to be good people, well-intended people, and not people who are being picked because they are going to do something. So while I get the perception based on what you see in the media, reality is different.
Just want to point out in terms of the numbers, they probably went by too fast, but only 7 states have partisan elections for state high courts. Only 6 have it for appellate courts, and 8 have partisan elections for all general jurisdiction trials.
Just a few comments in support of the speaker's points tonight. First, I think Northeastern should take great pride in the fact that one of its faculty established the modern Massachusetts Judicial Nominating Commission, Governor Dukakis, in 1975. Before his term, Governor Sargent had used ad hoc committees to find highly qualified candidates for the Massachusetts Judiciary. Mike Dukakis then institutionalized that process through the creation by an executive order of the Judicial Nominating Commission. Every governor since then has been afraid to contradict Mike Dukakis' institutionalization of integrity in the Commonwealth. And as Nan Duffly said, the application for an opening in the Massachusetts judicial system is intimidating. It is about a 35-page document, requires, I would say honestly, 40 to 80 hours of careful ripening. And when I have recommended that friends apply for a judgeship, I've sent them a hard copy. As a 20th century guy, I do mostly hard copy, and told them to keep it in their briefcase for a year or two and to consult it periodically and to gradually expand it, because it does force you to think about your entire life from secondary school onward. It causes you to appreciate your parents, your friends, and all your great teachers. And it teaches you a lot about yourself. Once you're through with it, you say, even if I don't get this job, I've learned a lot about myself by simply filling out the application. If you make the first cut, the commission invites you in to look at 21 of them around the horseshoe table, and that can be very intimidating. You make that cut, then you get vetted for your total history, your taxes, your criminal record, if any. If you had a bad night in college once, that will come up. And then if you make it through that cut, you'll get sent over to the governor's office, and the governor's chief legal counsel and his or her staff will have you in and examine you thoroughly. If you make it through that cut, the governor will have you in to size you up to make sure you're not a bomb thrower. And then finally, the governor will consult the joint bar committee consisting of members from the Massachusetts Bar Association and the Boston Bar Association, a group of distinguished practitioners, usually on an informal basis, to learn of anything about your temperament or your history.
I never correct you, but I'm going to correct you. I think it's county bars too. It's a large group.
I know that for district court and probate court judges, they'll go to the counties where the person is likely to sit. And then if you finally get nominated, you enter the twilight zone. You go to the governor's council, which is a very unstructured process. And if there's a full moon the night before your hearing, you never know who's going to come in from Beacon Street to talk about you. If you've been a trial judge, you've built up a record and you've decided cases against certain lawyers and individuals, and you're likely to see them there if you've been a trial judge before you want to become an appellate judge or another kind of trial judge. So it's a very exhaustive procedure, and in Massachusetts, I think it parallels the ABA procedure. And again, if you ever see Mike Dukakis walking across campus, you should go up to him and salute him and thank him for his characteristic competence and integrity. Just one other thought. Nan caused me to worry for a moment when she said she had been tutored by Sam Adams. But it was a descendant of Sam Adams by the same name, who was a great lawyer and a great judge. But Sam's cousin John may be the father of us all. In David McCulloch's biography of John Adams, remember, he set out to write a biography about John Adams and Thomas Jefferson and their long relationship over half a century. And as he researched increasingly, he became so much impressed with John Adams that he decided to make the book exclusively about John. And around page 35 or 40, he recites a letter, quotes a letter that John wrote home to Abigail from what was then Portland, Massachusetts, when Maine was part of Massachusetts. And John describes his schedule for the next several weeks to Abigail. And by then he'd been practicing about 18 or 20 years. Remember, he had defended the British officer in charge of the detail behind the old State House on then King Street against charges of inciting the Boston Massacre. He showed that someone in the crowd had yelled fire and not that officer. And that was a courageous case to take, even as a young lawyer. Well, he'd been practicing 18 or so years. He writes home to Abigail, here's my schedule, won't be seeing you for about a month. And he describes all his trials and appearances around the colony. And he's going to Worcester. He's going down to what became New Bedford. He's going to Martha's Vineyard at one point, and he's on horses and buckboards. And then he refers to the need for good, strong judges who are unafraid to make decisions in each of those towns where he's going to be trying cases. And that was really his great insight. He was a real lawyer long before he became a Constitution writer. So in 1779, when he's writing the Constitution, he puts in Article 29, makes judges independent. 8 years later, he goes to Philadelphia and he makes sure that that provision is in the federal Constitution. So you can never thank John Adams adequately enough for his courage and his experience.
He's such a font of knowledge, really.
We were on
So much of that is
the night school.
preparation.
There were about 4 or 5 of us who stayed around the courthouse at night to do our best thinking. The difference was Nan got there at the right time in the morning. So I read that Winston Churchill didn't start his day till noon, so I always admired the great Sir Winston.
Thanks, everyone. Whenever we hear of Supreme Court or whatever, the phrase, oh, we're only here to call the balls and strikes comes up again. And of course, that's not what's happening at the Supreme Court and I presume the Supreme Judicial Court, because there's the stuff that comes to them is the stuff that isn't obvious. But at the levels below that, we still end up with a lot of 2-to-1 decisions or 4-to-3 or what have you. If calling the balls and strikes were a useful metaphor at all, I would have thought that would be useful at the lower courts because the problems are less obscure. why are there so many split decisions at lower courts? I guess what I was thinking about, you were talking before, there was background of the people, but the law is the same. You're talking about judicial philosophy, law is the same. Is it those two things, basically?
I don't know, Mitch. I mean, I don't remember a lot of split decisions.
Thanks. There are surprisingly few of the hard-bitten split decisions in the lower courts, including state courts and I think even in the federal circuit courts. But the popular model is the Supreme Court. I noticed Marcia Coyle in one of our films talking about issues in the Supreme Court. But Justice Jackson, Robert Jackson, maybe the most underrated great justice of the 20th century, once said that the Supreme Court has maximum power and discretion when it's interpreting, quote, the majestic generalities of equal protection and due process, unquote. And those majestic generalities produce a great deal more disagreement and philosophical disagreement than will, say, a breach of warranty or the meaning of negligence, which are typical of a meaning of a contract clause, which are the typical work of lower courts, especially the state courts. So the other point is, I'm amazed sometimes at the comments that the Supreme Court justices make about each other's intellect and their opinions, and it would be unheard of in our court culture for colleagues to refer to one another that aggressively in their written published opinions. So again, I think the Supreme Court model is somewhat misleading. And sometimes, Nan, correct me if I'm wrong, sometimes you have to calm down a new law clerk who sends you a draft early in the year that is very aggressive and ideological, and you have to say, well, wait a minute, we don't, I know the Supreme Court does that in Washington, but here in our culture, we don't refer to colleagues with that kind of intellectual hostility.
I'm going to go back to something you said. So when we've had dissents on the appeals court, let me go now, and we've done that. It's usually because there is some question. It's not just, I disagree with you, I don't like your decision. And so, let me go back to my SJC hat. Part of our job every month is to take about 100 petitions for further appellate review. And it's a big court. It generates, in those cases, the ones, we look at all of them, every single one, but the ones that really generate interest is when there's a dissent. And if the appeals court is dissenting, we want to know why these smart people on the appeals court have a disagreement. And sometimes we say, oh, okay, yeah, we want to take that. So that's why we get it on further appellate review. And sometimes we say, no, not yet, or no, you know, that's not a type of issue that we want to entertain at this point. But it's usually not pure, I don't like what you said, is I think you're wrong in the law, right? Wouldn't you say?
Yes, absolutely. And actually, a lot of the uncertainty comes from the United States Supreme Court cases, which state courts, of course, must obey the federal constitution. So if the Supreme Court produces a new decision about usually criminal procedure in our trial courts, lawyers in Massachusetts, we have a very vigorous lawyer culture. And so we will get an appeal from the trial courts about a recent U.S. Supreme Court decision. How do we interpret and apply it? So we are trying to interpret Supreme Court decisions, and that often generates disagreements about interpretation. So, but one thing judges must do, as Judge Duffly pointed out, is to provide written reasoning for their decisions. And unlike the other two branches of government, which can make decisions often without written reasoning or on the basis of simple policy preferences, the judges must always use logic, precedent, and occasionally policy disagreements. They decide what interpretation of a statute fulfills the intent of the legislature or best serves a public policy. But you always must provide written reasoning for any significant decision. And that's, if people are worried about judicial independence, that's one of the great checks on judicial independence, along with the rule of precedence and the process of appeal up a chain of command. So not too many judges are going to acquire an excessive amount of autonomy until you reach the U.S. Supreme Court, probably.
Is there a problem with the culture of the U.S. Supreme Court? I mean, thinking about how different the U.S. Supreme Court has been in the last few years, I can't put a date to it. And what we see actually at the lower courts, both in federal courts and state courts, right? The place where we sort of assume that there will almost always be a dissent, that was not always the case. The sense, right? And of course, it's probably more on the well-known cases, right, where people begin to assume that there are blocks and voting blocks. What can be done to sort of rebuild that sense of collegiality, where opinions are not quite as harsh, or where blocks don't seem quite as firm? And am I wrong for thinking that that has probably a negative impact on the population's confidence in the court, because they begin to think of them as kind of, you know, players on different teams?
I'll try to respond. And this is more personal opinion than anything else, but from what I have seen and understand, there's a fair amount of collegiality on the United States Supreme Court amongst the justices. Some of what you're referring to, I think, was triggered in part by Justice Scalia and his writing style and his willingness to call things exactly as he saw them, regardless of the impact that it had. But the flip side is that one of his best friends was Justice Ginsburg. And the families socialized together and spent time together and spent holidays together and did it. But philosophically, they were completely opposite of each other. You hear rumors, and sometimes it's through books like Jeff Toobin's book, but you do at times, you know, get an inside glimpse into some of what goes on, and some of it isn't so pretty. What we can do about that, I don't think we can do anything about that. But certainly in states where there are elected judiciaries, the public can do things. And you know, I recently was in Wisconsin, which brings it to mind, but the Wisconsin Supreme Court has historically had a horrible time getting along with each other, to the point where two justices actually get into a physical altercation that made national press.
I would say both of them. I would only say one of them.
One attack. Okay. I'm trying to be judicious. But in any event, I think on the more local level, we can have an impact. When it comes to the federal judiciary, they're beyond our reach. But I also don't think the actual functioning is as bad as perhaps we think it is.
To go back to the Supreme Court, this is something that has really bothered me for years, but you both talked a lot about equal justice, equity for poor and rich. You know, it's regardless of your station in life. And the Citizens United decision to me it seems like such an un-American decision. We now have so much money in politics. And I've read that was sort of a mistake. Is there any way it can be undone without us clearing out the house?
I mean, the only way for it to be undone is either through legislation that survives constitutional scrutiny, or through a new issue that comes up to the Supreme Court where they either clarify or change their prior opinion.
I mean, legislation could do it. If you remember the case of, what's the name of the woman who? Yeah, the Ledbetter case, where the court decided in some way that wasn't beneficial to women in her position, couldn't reach back far enough to make it beneficial if you'd been discriminated against in pay. But then there was legislation that changed that. So there's another branch, and that's why we have 3 branches. Maybe that's an area.
Okay, in Citizens United it's a lot harder, because Citizens United is a constitutional decision,
Yeah.
and the letter is a statutory decision. So
That's why you said constitution.
Yeah, right, yeah.
The hair and
That's right, the new legislation would have to be crafted
Right.
somewhat differently. But the court could change its mind. I mean, that could, a different court could have a different view. Or we could have a constitutional amendment, which some people are working on right
So in a lot of ways, this is clearly the most diverse the Supreme Court's ever been. But in other ways, it's a very homogenous group. You look, 8 out of 9 justices had judicial experience before their appointment. And they come from 2, or technically 3 law schools. If we look towards the past, justices like Earl Warren, who was serving as governor before his appointment, it seems very unlikely that someone with that political past would be able to be appointed now. And so I guess what I'm trying to ask is, do you think that there's any problems with the Supreme Court having almost like a set path or a right way to get there? And are we losing something from a lack of diversity and experience?
Just hoping you did. What have you seen coming up that you wish that they were, you see so many appointments, right? Are we missing opportunities here?
I don't believe background is disqualifying, but there is, at least within our profession, a belief that either trial experience or bench experience is a prerequisite to being, at least in the federal courts.
I have to agree with that. I mean, it's not a disqualification, but it would be rare to get to that point in your career and not have had the benefit. Looking back now, I might have thought that 25, 30 years ago back. I can't think it now because I've learned so much that I didn't know. I didn't even know. I wasn't, I didn't know.
What is the breakdown of the Bar Association in terms of gender or, and other kinds of diversity?
I don't know that I can answer that question. I believe our profession as a whole is probably, and maybe the dean or Wendy know, but is 55 to 60% male versus female.
I meant the 15.
Oh, on our committee. Oh, goodness. Wished I'd had this in advance. I would have counted. Our committee is diverse. I would say it's roughly 50-50 male-female. Clearly diverse in terms of race. I don't want to begin to guess at ethnicity, and I certainly have no clue in terms of disability. But I feel, in orientation, I'm not sure. But I mean, the committee is reasonably diverse.
The ABA has policies about how to staff committees, important committees. They really demand it.
I should also add we have both plaintiffs and defense lawyers on the committee. We've had judges on the committee and law professors. So there's, within the profession, a diversity of perspective as well.
Hi, this is really loud. My name is Siri Nelson, and I'm a 2L at Northeastern University School of Law. So I've been sitting here trying to think of a good question that doesn't involve, like, how do you get a clerkship at a... So what I wanted to know was, what do you do when you're faced with a really challenging issue related to a technology that you don't necessarily understand? And how do the electronic presence of judges factor into your decision-making process when you're certifying them for the Supreme Court?
So that first question was for me, right?
Yes.
Very often, particularly on the SJC, I would get an issue that I don't know anything about, take a big breath and feel really scared. And then I remember that I'm pretty smart and that I just need to study and go way back and learn. And that even if it looks really hard the first time, I read it again, and you read it again, and then you get it. Sometimes it takes longer, and sometimes it doesn't take so long. But I've certainly encountered a few times things that are completely out of my experience, and I really, really needed to answer the questions. So I go very broadly too. So just to get the the landscape before you get to the question, right? Is that what you're talking about? Yeah. So we all do that. That's what's pretty amazing appellate court and our court. I mean, you have to do it. I don't remember your other question.
This one was more for Peter. How do you take into consideration the electronic presence of people that are being considered for the Supreme Court?
Great question. I turn on my computer, I launch Google Chrome or Internet Explorer, and I start searching. And it's amazing what you find. I can go on Facebook. Most nominees aren't Facebook savvy, so they're not there. But you look, I mean, you scour things and look. Also, in the questionnaire that they fill out, there's always a list of either interviews they've given or TV appearances, whatever. And sometimes you get into those and then can launch from there and find more material. But it's in a host of ways. But we try hard to find what isn't out there. We had one nominee, and there was a reference to an interview that the person gave that was on YouTube, where something that a lot of people would consider terrible was said, and those things get found, hopefully.
Can I follow up with a question about the Judge Kaczynski, what happened, the scandal, let's call it that, and the whole Me Too movement? Is that influencing at all, or is your committee thinking about additional ways to probe more deeply into inappropriate behavior that may have happened in the past, that, in the past that people weren't willing to talk about?
I would say, the best I can say is we're always thinking about how we can improve what we do. And I'm not saying this is on our agenda, because we actually have a meeting on Monday. And we haven't met since as a committee in person, we haven't met since, I believe it was last August. So I haven't seen the agenda yet, but it's clearly a hot topic. So if it's not there, it will be. And by continuous improvement, the process I talked about in terms of when somebody's not qualified, having 2 independent reviews done, has only been in place now for about 12 years. And it's because we decided, or my predecessors felt, that was the better way to go at this.
I want to go back and answer your question before about the balls and strikes and the 2-to-1 dissents. I think one of the most important things that I would hope that people would get out of this whole open classroom experience is that just because the law isn't mathematical in a whole variety of moments, that doesn't mean that it has to immediately descend from non-mathematical to whim or partisan difference. There are all kinds of situations. When the World Trade Center 9/11 happened, there were insurance policies which had caps. So-and-so much money we're going to pay for an event. And the question was, when the planes hit the 2 towers, was that 1 event or was it 2? Right? And there's no easy or obvious answer to that because no one ever imagined that anything as horrible as this would ever happen. And that's just one example, but that kind of thing happens all the time. That life just throws unusual circumstances, and reasonable people disagree. And you get 2-to-1 votes, and that doesn't mean that they're, like vanilla ice cream or chocolate. It means that they're trying as hard as they can to figure out, based on limited information, what they want to do. If we treated every disagreement of that kind as that means we don't have the rule of law anymore, then we wouldn't have a rule of law, and we'd have a situation which would make us all a lot more scared and unhappy. And I think that's actually one of the biggest challenges that the legal community has in talking to the public. This already sounds complicated. Oh, you're so complicated, but it is complicated, and that's the best we can do.
I have an example that occurred to me. I don't remember if you were on appeals court with me at the time. there was an issue involving whether something was an aggravated rape or not. And the aggravation was if there was violence involved. And the question was whether the violence had to be before or during the sex act of rape, that was part of the rape incident, and it wasn't if it was after. And there was disagreement about whether, which was the case, right? And some people felt that the penetration part was the rape, and other people felt that the incident of violence, which includes anywhere within it an act of sexual penetration or other act that was sexual that made it rape, that made it aggravation because the whole thing is rape. So that was where we disagreed on the appeals court, and it went up to the SJC, and they agreed with me. But I was off the panel, so it was. But we had a very robust discussion among all members of our court. There were at that time like 24, something like that, which we did. I mean, oh, that's another thing you don't realize. It's not just the 3 people on the appeals court. It's everybody on a published opinion that has a voice, because it used to be an en banc court, so everybody weighs in. And we disagreed, and you could see the disagreement in the number of people, but it was a broader disagreement than that, and the SJC took it up and made a decision.
In circumstances where there's a panel of judges making a decision, like the Supreme Court, how do you make it when you're judging people individually by only how good they are at reading law books, and not necessarily what their political persuasion is? Where does that balance get accounted for, so that you don't have a far right or a far left court, so it leaves somebody out?
From my experience, there are courts that lean left or lean right, perhaps even far left or far right. That was a major focus of why there was something called tort reform 20 years ago, because in some states there was a perception that the judiciaries had blown way too far to the left and needed to be pulled back, I suppose.
And Trump is threatening to put him way far to the right now, and he's getting probably the opportunity to give it a try.
Well, he's certainly nominating people with a conservative background. But the people who are being nominated still take an oath to adhere to the rule of law, to obey the Constitution, and in virtually all instances have had some type of bipartisan vetting. So will they be conservative on balance? Yes, but what that means in the vast run of cases is the result will be the same. And I suppose in the cases on the margins, it remains to be seen what those cases are and how they're decided. I mean, we have a country that everybody, or virtually everybody, lives by the rule of law. I mean, the greatest example I can think of that makes this clear is Bush versus Gore, perhaps the most controversial Supreme Court decision of my adult life. And no matter how strenuously the 5 versus the 4 disagreed, no matter how strenuously those on one side or the other disagreed, when the decision came down, the case was over and the government opened for business the next day. We had a new president. Everybody respected whether they agreed or not, and the rule of law survived.
Will the environment survive? You know, or some other environmental justice survive?
We have many more weeks to consider that. So next week we're going to talk about access to justice and the role of lawyers in maintaining the rule of law, and how important it is for people who can't afford a lawyer to have one in certain circumstances. Let's give our speakers another round.